Everybody, I just want to say thank you so much for joining in on this reentry panel dealing with child support with us. This does not serve as legal advice, but information advice to help educate people on how tax matters are being resolved during the COVID-19 pandemic. Without further ado, we're about 4 minutes into it and we have so much information. I am ready to get started. So I'm going to start off with myself. For those who don't know me, my name is Shemitria Gonzalez. I'm the community organizer at the Justice and Accountability Center. I'm the founder of a project called Forward, which is focused on real women and real dreams. Use that to go into the prisons and to help women that are in reentry to heal mind, body, and spirit. So we do a lot of different alternative healing programs, and we do a lot on mindset shifting. Before that, I was a medical advocate for UMC Hospital for victims of sexual assault. I worked in New Orleans Family Justice Center, assisted victims of domestic violence as well as sexual assault. A coach. I was a student athlete at Southern University in New Orleans. I'm from Texas. I came down here and really started my whole advocacy life. Again, mine is like short and sweet, but I'm about to get into these other two bios who I'm just so excited as a young person who's in this work and hands down to the ground to have like the pleasure of being on this call. And Judge Benedette D. Souza.
D'Souza.
Souza. Oh, I was trying so hard. So Judge D'Souza was elected as the first family court judge at Civil District Courts for the Parish of Orleans on February the 1st, 2012. Judge D'Souza was previously a practicing attorney in public interest law for over 18 years, many of them as managing attorneys of the Family Law and Domestic Violence Unit at Southeast Louisiana Legal Services. That's my girl. Judge D'Souza received her doctoral degree from Tulane University School of Law in 1992. Upon graduation, she dedicated her legal career to public interest law representing indigent clients in family law, housing, and domestic violence cases. She has spent over her decade promoting awareness to domestic violence issues by devoting time to educating and supervising law students from Tulane Law School and from around the country post-Katrina. The judge served as a professor at Tulane Law School, teaching a course on family law and domestic violence and instructing students through a clinical internship program. She also served as a guest lecturer at Loyola University College of Law on topics of domestic violence and poverty law. The judge now serves on the National Council of Juvenile and Family Court Judges facility of the National Judicial Institute on Domestic Violence. As a survivor, I just want to say thank you, Judge. Like, as I'm reading this, I'm just overwhelmed at the amount of work, but I will continue. Judge is a member of the Louisiana State Bar Association and served on its Access to Justice Committee, the New Orleans Bar Association, and served as the past chair of the Family Law Committee, the American Bar Association Family Law Section Domestic Violence Executive Committee, the AP Turo End of Court, and the Association for Women Attorneys. She is a fellow of the Louisiana Bar Foundation, where she served as the chair of the Judicial Liaisons Committee and the chair of the Developmental Committee. Judge has been appointed by the Supreme Court to the self-represented litigant task force and the Committee on Bar Admissions. Thanks, Judge. Additionally, Judge has served on many community boards. She served as president of the Greater New Orleans YWCA, Tulane University's Women Association, and the auxiliary of the American Academy of Neurology. She served as chairman of the board of WRBH Radio for the Blind and the board member secretary for the Institute of Mental Hygiene. Judge is a mayoral appointee by the Board of Total Community Actions. Upon election to the bench, Judge became a member of the National Association of Women Judges and was appointed as co-chair on the Domestic Violence Committee. She was elected to the board of the NAWJ as district director, secretary, and served as chair of the personal committee and co-chair of the executive director search committee before becoming her election as president-elect. Let me wipe my
breath.
When I read it was just so amazing to me. So, I mean, I will continue to go on, but just guys, if you are listening, just soak that in before we have anything come out of this lady's mouth, that it is something that we are valuable and just grateful to have you on this call. I want to say that myself. As we continue to go on, she will also be on this panel next to Miss Naomi Kim, who's a founding attorney at a local law firm, Naomi B. Kim, APLC. So Naomi is a founding attorney at a boutique law firm serving diverse legal needs of Greater New Orleans metro area and surrounding parishes. Among the area of law that she practices is family law. Naomi's experience and background in family law began when she served as a judicial law clerk for the sitting family court judge, the Han Paulette R. Irons, for the Orleans Civil District Court from 2009 to 2010. Her experience in this area continued as she represented mothers and fathers in various family law cases over the years. Naomi is delighted to share that the law firm is in the stages of launching the expansion of service in the area for estate planning, succession, business startups, and nonprofit startup services. This is so exciting. In addition to her law practice, Naomi serves as a hearing officer for the City of New Orleans Administrating Hearing Center, where they conduct hearing for contested parking and camera tickets. She also serves as a certified and trained moderator for the New Orleans Office of Independent Police Monitors, where the mediation program provides a space and opportunity for civilians and police officers to mitigate their issues. Naomi enjoys giving back to the community in various ways, one being her service as a member of the LSBA's Building Bridges Committee, along with volunteering in the past with JAC's Reentry Court and Clean Your Jacket Expungement Drive / events. Guys, we are about to get right into it and just dive into these questions, but sincerely, Naomi and Judge, I'm so excited that you are here. So without further ado, I know just like everyone else, today's panel is going to be talking about reentry and child support, which are two things that are really, really important, especially in these post-COVID, if you want to say post, during, post, past COVID times that we are in right now. So the first question that I have is going to be for Naomi. I'm sorry about that. There's an important change to the child support law going into effect for incarcerated individuals on August the 1st, 2020. Naomi, can you please explain what this change is and who it will affect?
Thank you, Shremetria. I want to thank JAC, first of all, for inviting us to this panel discussion, and also to be in the presence and to be on this panel with Judge D'Souza is firstly an honor. Of course, I would like to share with you this exciting news. We have this law that has been passed, I believe so, in 2017, but it's finally going to be effective, like Shremetria just stated, August 1st, 2020, which means in a matter of a couple of days. And this is a phenomenal change in the law. And basically what it provides for any person who is about to be incarcerated for a period of 180 days consecutive, that means back to back, or is in the process of serving a sentence for that, at least that amount of time, then they can actually obtain relief for requesting that their child support obligation, so this means there has to already be a child support obligation in existence, for that to be suspended. And what that means is whatever you owed on a monthly basis before will actually go down to zero. And so you will not be responsible for paying child support during the months of your incarceration period. Of course, there's 3 exceptions to that. In the event that you are actually able to sufficiently pay your child support, even though you will be incarcerated, then that's an exception, meaning you still have to pay child support. If the reason why you're incarcerated is due to some type of charge, some type of, I guess, situation between you, basically an offense that may have happened between the person who's being incarcerated and the custodial parent or the child in which this child support is for, then that's an exception, meaning you still have to pay child support. And the third one is if the reason for your incarceration is because of non-payment of your child support. So those are the three exceptions to that relief. But other than that, that is something now in a couple of days that is available. I don't want to belabor, there's internally, the state of Louisiana, under the Department of Children and Family Services and the Department of Corrections, there are certain procedures in place in which they do have to come together with the plan in order to make sure this rolls out for everybody. If anyone wants to actually know what the law is, it's Louisiana Revised Statute 9:311.1. The one thing I do want you to know is that the child support will become reinstated on the second full month, that first day on the second full month that you have now, served your time and your incarceration period has ended. So just know that there's a little time that they kind of give you, but then the child support obligation, that monthly payment you have to make will come back and restart. So that's just a synopsis and a summary of the law that we're looking forward to rolling out in a couple of days.
Thank you so much for that, Naomi. Thank you, thank you, thank you. So for the people out there that got all that information and took it in and just may not know exactly what you meant, I have a question for you. So let's say that somebody was incarcerated and they don't know if they have a child support order or never got the paperwork. How can they find out if they have the child support order with the court?
That is an excellent question. And that does happen quite naturally and often. My suggestion would be to first just recall where your children or where your child, what parish that they have lived in. So my first step would just kind of figure that out. And then you can look up online the clerk of court office phone numbers and to give them a call and provide your name and just simply say, I'm just trying to see if there's any cases that involve me. And the reason why I'm suggesting this as a first approach is because especially when you're pro se and you're not represented by an attorney, sometimes calling the state immediately, you might be a little uncomfortable of what information you should share or what you should not share. But this way, the clerk of court is a neutral party. You can just frankly ask them. They're very helpful. They will let you know, they'll look in their system and they'll see if there are any cases involving your name. If for whatever reason, there's no information that comes from doing that, then it is my suggestion to call the customer service line found on the Department of Children and Family Services website. I have the number here, and we also kind of have, can make that information available to everyone, but it's 1-888-LA help you. And that's the main number for the state of Louisiana. And you can call them and give them the information and just request that you would like to know if there are any child support enforcement cases open where you're involved. Sometimes they may need a date of birth or so just to make sure if some names are common. So in order for them to accurately provide you that information, that might be necessary. However, if you actually speak with a caseworker, I think if they start asking, if they find your case and they're just kind of asking a lot more questions of where do you live? What's your address? Are you working, et cetera, et cetera. I'm not telling you to not be cooperative, but at the same time, I think it's okay to say, I feel a little uncomfortable maybe answering those questions at this time. I think I might want to consult an attorney before you provide all that information. Definitely want to encourage being cooperative with the state, but at the same time, you have an interest to also protect yourself as well, especially as a pro se litigant. Oh, and the only other thing I wanted to mention was I did get to speak with someone at the Orleans Parish District Attorney's Office, and I was able to learn that just because we're in COVID and the caseworkers and the attorneys are all working remotely. So just please know it is going through a chain of process. So even though you call the customer service line, you're leaving them a message, they are funneling your message to the appropriate caseworker, to your case, and they will call you back. But please know that they might be calling you back from an unknown or a private number. So, I mean, if you can, please answer it. I mean, I know we're all leery of those numbers because of so many scam calls, but unfortunately, I mean, this is kind of the information that I was provided.
Thank you for that, Naomi, so much. That's a lot of juicy information. And to anybody out there watching, please don't forget, if you have questions, I know we're just going to be going through these really fast. Don't forget to put them in the chat, as well as just stay looking at the chat, because we're going to continue to post different numbers and links in there as we go. So just moving right along. This one's going to be for the judge. So this question is, are child support payments suspended during COVID-19?
No, child support payments are not suspended during COVID-19. While the state is not enforcing the child support by filing rules for contempt for non-payment, or arrearages continue to accrue during COVID-19. So any party that's subject to a child support judgment should follow their current judgment, unless they file a rule for reduction and come before the court. And that's when the court can act.
Thank you for that, Judge. Thank you so much for that. The next question I have is going to be for you as well. This is just theoretically. If someone was on a child support payment plan, but they lost their job because of COVID-19, what should they do?
Okay. If someone experiences a loss in income, they should immediately file what you call a rule to decrease child support. I see those cases now, and I'm sure I'm going to see them more frequently, where someone was ordered to pay child support and then lost his job, and the state then has to recalculate, because what you have in child support cases is the child support Louisiana child support guidelines. It's a formula that they plug in what the income is of each, either the custodial parent and the non-custodial parent. And once they put in the formula, they'll get the approximate percentage of what that amount is that needs to be paid, or their portion is of that child support. And so when that is calculated based on their income, then the amount can be reduced. I had a similar case yesterday, and I pretty much, given the evidence that was put before me, both parties just received the federal unemployment, which sadly I understand is going to be, they're no longer going to receive it except for unemployment. And so they imputed a minimum wage to them, to both parties, and came up with an amount. However, what we did was basically by consent of both parties, agreed to make it an interim order so that if the person gets a job, then they can go back and start paying that amount. So there is some sort of a way of dealing with the COVID-19 crisis.
Thank you for that, Judge. That was a lot of juicy information. I'm sure that can help someone out. So the next one that I have, I guess you can say it's kind of sort of on the same lines of what I just asked you, but this one is, if someone is behind on the payments because of COVID-19, what can they do at that point?
If they're behind payment on COVID-19, I'm told by the Child Support Enforcement Office that they should contact their caseworker immediately. They can call 1-888-524-3578 and discuss a payment plan so that they can get back on track to make their regular monthly payments, which oftentimes is much better than ignoring paying any portion of that payment. So that's what the child support enforcement attorneys are looking for people to do during the time of this amount that needs to be paid. We will see an increase of cases due to COVID-19, but I think a lot of them have to be aware that in order to come before the court, they have to file a rule to decrease child support so that we can assess what their situation is and determine what is the appropriate amount. Because while you want to consider and prevent any incarceration of a non-custodial parent for not paying child support, you also want to make sure that there is food on the table and clothing for the kids so that the families are taken care of. And so that's the balance a judge needs to look into.
Thank you for that. I wish there were more people that thought like you. That I totally agree 100%. And I think just having that mindset will also, I mean, it's only fair, but just for people to not have this information, I think is the biggest thing. So just getting this to them as much as we can so they know what can be done. I think that's a lot of power in that and just having that knowledge. So the next question that I have is going to be for Miss Naomi. And that is, can my coronavirus payment plan be taken to pay child support arrears?
Thank you, Shamitria. Before I forget, if I may, I just want to dovetail on something very important that Judge D'Souza has been saying in her responses, which is to file this. It's very, very important to file this rule to decrease child support. And you have every right to, this is exercising your own right to really explain to the court, your situation, whether you lost your employment due to COVID, et cetera, et cetera. Now, before COVID, the self-help resource centers were open and available both in Civil District Court of Orleans Parish, along with the 24th Judicial District Court in Jefferson Parish. I went on the Pro Bono project, their website, and they did provide an update that due to COVID, they are closed. However, they did provide both a phone number as a self-help hotline, which is 504-581-4042, along with an email and self-help@probono-no.org, which this information we would like to make sure it's available for those who are interested. So I think if you have questions about how do I file a rule to decrease child support, is there a form available, et cetera, that would be a resource that I would suggest calling or emailing first. Additionally, I did look in the
May I
law.
just add that that the forms are available, Naomi. We have those forms for rule to decrease child support right near the self-help desk that was situated on the first level of the civil district court. So we
Okay.
do have the forms. If they come, they can fill out those forms for rule to decrease child support. If they have questions, they can contact the Pro Bono Project as to how to go about to do that. But they certainly can file it up at the clerk's office, and the forms are available.
Excellent, excellent. So just something just to make sure that everyone knows that those forms are available out there for you. But to go back to your question, yes, so the CARES Act, which was enacted because of the response to COVID-19, unfortunately, the way that that act was constructed was if you have child support arrears of at least $500, then that stimulus payment was intercepted by the state to go and apply it towards your child support arrears. And the state's hands is really, their hands are tied because the legislation did not provide them with any authority, any decision making of whether they could reduce that or not do that at all. They literally have no power over that. They do have to follow what the CARES Act had stated above. There's no way to decrease it or anything. The only relief that was provided was if you are married and you file jointly with your spouse, then your spouse could go through and there's a procedure of they would have to apply and basically request that part of that stimulus payment that would kind of maybe go towards them for that consideration of receiving some relief. But as to the non-custodial parent who has child support arrears, that stimulus payment is has been intercepted and you're not able to receive any of those funds.
Thank you for that, Naomi. And I have something that is kind of similar to that, but this question is, how can I claim a portion of my coronavirus check if it has been garnished? And I think you kind of answered that, but just so they can be clear on that portion.
Okay, so if you're a person who owes child support and has child support arrears, then at this time, the way that the law has been written, there is no relief available to you. There could be in the event that you have a spouse and the spouse may be able to receive some type of relief.
Thank you for that. That definitely makes sense to me. So, Judge, we have been on Naomi for a little while now. I got something for you.
Sure.
Let's say someone had court scheduled and then COVID-19 disrupted it. How would they get their court rescheduled? Where would they start?
Okay. So if the hearing was scheduled during the time of COVID-19, when there was a total shutdown of the court, the state district attorney files a motion to reset the court hearing, which was originally scheduled. Then we, as a court, do the ex proprio motu, which means the court will reschedule the hearing. If not all of the hearings are scheduled during the shutdown, so long as the other side receives proper service, the court will reach out to both parties and clear the dates with them. And that's what my minute clerk has been doing. She reaches out to both parties, clears the dates, resets it, and she mails out those ex proprio motu orders as long as we are able to communicate with the parties. We need their addresses to mail it to them and that they have indeed received service of the order to have the hearing. If the party is not a state district attorney case, the initial pleading that was to be held and the opposing party never received proper service, then the party must reset the matter by filing a motion to reset. So to give you an example, if someone who files the initial petition, the motion to set it for a hearing, and then the defendant does not receive proper service, the petitioner then has to file a motion to reset. And all these forms are available in the clerk's office on the 4th floor of Civil District Court.
Thank you for that, Judge. I'm going to go ahead and put that information as well. You said they are available in the 4th floor.
On the 4th floor of the Civil District Court, the motion to reset the hearings.
Gotcha. Thank you for that information. So as we continue, we're moving right along. I have another kind of scenario for you. Let's say someone was recently released from being incarcerated and now they owe child support. What can they do? Where would they start?
I know if Naomi wants to speak to that very briefly about a case that she had, I can then give the judicial perspective on it.
Yes, thank you. Sorry about that. Naomi?
Thank you, Judge. So something that we've kind of discussed prior, I think the appropriate pleading would be a rule to decrease child support, because we have to get our foot in the court first and foremost. And then, so that's kind of getting that started, but we also do need to compile as much documentation or evidence to prove that that the incarceration occurred. And then, of course, the difficulties of finding employment. So maybe your different attempts to finding employment. Some people did find some jobs, but then, they may have lost the job. So letters possibly from the previous employer to just state that so-and-so had worked for me, they are no longer with me, or possibly affidavits from other people who can validate, the situation of what this person is going through. I mean, the reason why and these are only suggestions, we can be as creative as we would like to be. It's just important whenever we bring this case before the judge that whatever we're presenting, whatever relief that we're requesting, that we want to make sure we can support it with evidence just to show and confirm what this person is going through, and that's why they're asking for this type of relief. Judge, I think that's kind of my tidbits.
Yeah, and you're right. Unless and until you bring the evidence before the court, I'm at a loss to make a decision, right? And so
Right.
you gather as much information as you can. Sometimes they come to court and they say, I do have a witness, or I worked with somebody and they can come testify that I no longer work there. So I said, is that person here? If they'd come prepared, then it makes it so much easier to then get their testimony for me to make an informed decision, based on the facts and the law and the evidence that has been presented to me. But I oftentimes say out there for everybody to know, when you are unemployed, when you are incarcerated, and the court is not aware of it, the way you come into court is to do that rule for reduction in child support. Until and unless you do that, I'm not aware of your situation. That's the way you get your foot into the door at the courthouse. And the reason we have the self-help desk at the courthouse is to really for us to provide access to justice. Even during COVID-19, I don't believe that the wheels of justice should shut down. We should be working, and that's why we continued coming to court, following the proper protective guidelines for COVID-19. And we set out these exproprio motu and sent people information about their hearing and what date they were reset. But unless and until you do that, and get a rule to reduce for reduction filed in the court, then the judge is not aware of what your situation is. Sometimes people don't realize that there have been several months that have gone by, and they don't realize that each month the child support keeps on accruing, and it's very difficult to go back for a number of months. So as soon as you lose a job, as soon as you can't get employment due to COVID-19, you were paying a child support in the amount of $1,000, but now all you get is unemployment of $247. How can you afford to pay $1,000 a month? Because you've lost the job, but you got to come before the court. And then if it's going through the state of Louisiana, the district attorney will take the information and do the child support guideline worksheet. Okay. And get the appropriate amount that can be paid for the family.
Thank you for that so much. Naomi, did you have something else to add on that?
I just wanted to, because I did remember what you, in the question, you said that, this could be also a person who not only doesn't have, is not employed, but was also denied unemployment. So if that's the case, like a documentation that shows that you applied, you went through the application process of filing for unemployment, and then if you received any type of notice from that department saying, sorry, you just didn't qualify. So those are the type of things that would be another example of possible evidence to validate that you did attempt to collect unemployment and for some reason unknown to us, you were denied. Judge, the one thing I wanted to, it just kind of came into my mind was, I believe that, yes, the Civil District Court, along with some other courts, have resumed in-person hearings.
Yeah.
However, when I spoke with the representative from the Orleans Parish District Attorney's Office, they stated that most of these hearings are still done via Zoom.
Yes.
Okay.
I just did where every other Wednesday is my state day. Every other Wednesday, it's only by Zoom hearing because they've set themselves up remotely. I've done all my state, but there is such an advantage to that, because as I question the litigants about the Zoom hearing, they say they love it because Naomi, on any given state day, I have wall-to-wall people in my courtroom. And that's absolutely not possible to do during this pandemic. And so the Zoom hearings are so efficient because there are parents that are either sitting at home or are at their offices or in cars. They're just barely taking that specific time. So if they're working, they can get right back to work after 15 minutes or 30 minutes of their hearing. They don't have to wait for their court case to be called and for the district attorneys to figure out what amount of payment. And that's what takes a long time because their caseworkers come into my courtroom and they start working out those child support guidelines and they then give me the amount that they have to pay under the law. The judge has very little discretion as to what that amount can be. I can, however, I do have discretionary powers, but it has to be for good cause. for the amount to be deviated from the child support guidelines. And so it's good for everyone to understand that it's very important to immediately get those forms, file it, and then contact the caseworker so they can schedule your hearing with the court, and we facilitate it all through Zoom. It's been very, very convenient and efficient. I love it. It's really been good. Yeah.
That is amazing. Judge, have you encountered any people who may not have a computer or phone in which they could use the Zoom app?
So yesterday on Wednesday, we had a case like that. And one of the caseworker was able to share her phone with the person in her car. I thought that was incredible of the Child Support Enforcement Office.
Wow.
One of the caseworker did that. So I think they all understand the difficulties with other pro se litigants. That's why I am in court, because not everybody is equipped with the proper bandwidth to get on Zoom, or do they have the computer to do that. So that's why I'm here for in-person hearings, and for the ones that want to do it by Zoom, I'm available for that by Zoom.
Thank you for that clarity, because I actually was going to follow up and just ask for that vulnerable population that may not have that, if there was an in-person option. So that's good. I appreciate you for that.
Sure.
Thank you. So guys, we have about 14 minutes left, and we have a few questions. So far, guys, anyone who's out there listening, please, we are here for you. After 6 o'clock, the judge and Naomi will be gone, but this video will be up. But please, guys, if you have any questions, feel free to put them in the chat box. We will answer them at the end of this meeting. And I'm just gonna hop right back into it. So another scenario for the judge or Naomi, let's say that someone was recently released from being incarcerated, and they were not able to collect unemployment during COVID-19. They're not able to find employment or get unemployment benefits. They've been denied, but they have a child support payment plan. So they're not necessarily behind, but they're on a payment plan. They just, because of COVID-19, can't find work and cannot get unemployment for whatever the reason. What can be done? Where can they start?
I think I'm going to defer this to the judge. I think she has a great insight to this.
Thank you.
If they can't do their payment plan, all I can say is do a rule to reduce and come before the court.
Okay.
Even though there is a payment plan, because the judge can pretty much look to the circumstances that the family is facing. Yet has to keep in mind what is in the best interest of the children that need to be fed, So it's important to come before the court, unless they contact the caseworker and see if what portion of that payment plan are they willing to accept. But I do want everyone to know that the state is not filing any rules for contempt for failure to make child support payment for now during this pandemic, or to collect on the arrearages. They're not doing any rules for contempt that are coming before the court. And I was assured of that by the State Enforcement Office, that they're not going to do that. However, they advise everyone that if they can, to make some payment if possible. And if they're not able to make that payment, they should contact their caseworker, who can work with them to see what amount is possible to make their payment each month.
Right, and I just wanted to confirm that yes, in contacting the same office that Judge you're mentioning, they're saying, I mean, if you file a rule for a decreased child support, they are taking and considering those seriously. And if it's warranted, they will cooperate and try to work this out with you. So there was an openness with that office, the child support office, and really being open to these type of this type of relief. We mentioned a lot, file this rule to decrease. I just want to make sure that there is a cost at the clerk's office to file a rule to decrease child support. However, if you also file along with it what's called, for short, IFP, or in forma pauperis, it's an affidavit, and you fill out your basic information about yourself, where you live, and it does ask for your income, if you're working, your basic bills on a monthly basis, maybe how many children you have, et cetera, et cetera. And what they're trying to do is they're trying to see if you qualify for a deferment in paying your court costs. So, I think in this time of COVID, with people experiencing all kinds of financial hardship, if even paying the $47, here in New Orleans is difficult for you, please file that IFP form. And you can surely do this in Jefferson Parish. Any parish in Louisiana, you can file the IFP form along with your rule to decrease child support.
Nice.
Yeah, or any other pleading that they would like to file, a petition for custody or a petition for divorce. Any of those pleadings, if you fall under the 125 federal poverty guidelines, you're eligible to file an IFP affidavit with the court. It merely suggests that you cannot front the filing fee at the time of filing. The court then can determine who is assessed the cost. But initially, you don't have to pay upfront to come before the court. And that's the concept for access to the courts and access to justice for the vulnerable population of our city.
Absolutely. And one thing that I want to make sure, I just looking at my notes, is if you were to file your rule to decrease child support, you do have to serve that upon the state of Louisiana, which is the Orleans Parish District Attorney's Office. Typically, you just walk across the street to 1340 Poydras in Suite 1500 and drop it off there. Judge, do you know if there is a different location where people can, someone said they could slip it under the door.
Yeah, I think they probably have a mailbox that you can just put it in through the door, is what I understand. Because none of them are in the offices. The office is completely shut down. They're all working remotely from their homes. And so since the opening of court, I've just been handling it all over Zoom with video conferencing.
Okay, that's excellent, Judge. So I know a lot of the information here today, it's been very dominant on Orleans Parish. That being because we have an Orleans Parish Family Court judge, in our midst today. We just want to make sure we just kind of at least sprinkle a little information about just a few other parishes that this may pertain to you all. I looked in the Jefferson Parish. Usually these child support enforcement cases are conducted at the Jefferson Parish Juvenile Court. Mm-hmm. And they have since resumed in-person hearings as well. They have on their website, if you go, you can actually look up if your case is on the docket on whatever day it is. So you're aware if your case is scheduled to be heard. And the same protocol, pre-screenings before entering. Only people who are named in that case can appear there. You can arrange for your hearing to be done by teleconferencing or Zoom, but it sounds like you have to have that set up ahead of time. Similarly, in St. Tammany as well, they have resumed in-person hearings It seems like on a random, rare occasion, some of those are still being done via Zoom. And it's similar to most of these, and to enter the courthouses are all very similar. The masks, the social distancing. Only if your case is being heard. Sometimes the courthouses are kind of at their capacity, and they may ask you to please stay in your car, and somehow they'll contact you when your case is being heard, that they'll actually contact you then. And lastly, St. Bernard, they too have also resumed in-person hearings, and they've been keeping their dockets kind of small as well. And yeah, so that's just a little information. Please check if you can, the websites for whatever court that your child support case is filed in, and you can find the latest updates on COVID-19 and what the requirements are to go to court, and etc.
Okay. But once again, I really want to reiterate the fact that while Pro Bono Project is not here at our self-help desk at Civil District Court, I recently met with them, and they assured me that they have every form available downstairs. So if people want to come in and get access to those forms, they can do that and then go up to the 4th floor and file it in the clerk's office.
Thank you so much for that, for both of you guys. Thank you so much for all of this information. Again, at the Justice and Accountability Center, we believe that we are helping people with reentry, and we have a lot of different initiatives that we work on, whether it be expungement or stop in Louisiana, stop in solitary confinement. But the one that I like the most about this job is the common theme of continuing to get people that normally wouldn't be in the room to be able to service the clients that gave us today. Will be posted on YouTube, Instagram, Facebook. We're going to continue to try to push it out there because, again, like you said, something as small as them not knowing, thinking that post-COVID, everyone kind of like still accumulating, although they're not doing contempts right now to get people, for the most part, they're still accumulating those fees, if I'm not mistaken. I had one question from someone, and they said, what did contempt mean? So I'm gonna let Judge say that one first. Go ahead, you can go after it, and I'll finish up afterwards.
Okay, a rule for contempt, what the state child support enforcement office does is they calculate what the arrears are, and they come before the court with a rule for contempt for failure to pay child support. And then they'll tell me what the portion is and ask me if generally under the law, they will ask for incarceration for failure to pay the child support. What I do is I've never sent a single person from my court to be incarcerated. I give them an opportunity to come up with at least a small portion of the amount that is owed that the state is seeking, because they're always seeking a percentage of the arrearages. And whatever that percentage is, I will ask the state if he can come up with, say, 200, depending on each one's circumstances. If they can come up with $200 or $500, depending on what the arrearages are, I will give them the time, 15 days, 30 days. But if they fail to do that, then my hands are tied, because the law, says that if they fail to pay, then they gotta go to jail. And oftentimes the child support enforcement office believes that by throwing them in jail, they'll come up with the money. But that's not where I am, because that is counterproductive to get people to really feel like they can go out and find a job. I don't think that being in jail is the right answer. There is a way you got to work with it. And that's why the rule to reduce becomes very critical to come before this court, for the court to then determine, because then the court balances the scales of justice by seeing what the family needs are and what the non-custodial parent can afford to pay, so that, you know, each one is made whole.
Thank you guys so much for all of that information. Guys, if you missed it, you missed a lot of juicy information that is going to help a lot of people. But the last thing that I got to ask you guys, I normally do this, and maybe this is like a little winger, but I like to offer a word of hope to everyone that's watching this that feels discouraged. I know that's a lot of information. Some people may have heard things today that is not what they wanted to hear. Again, it may be a different array of things, but I'll offer one word as we close out today. And that word is going to be grit. To me, grit means, to anyone watching, is to continue to persevere and to move forward when you have nothing left in you, because once you get to that point, something magical happens and you're able to start all over and go again. So just never give up and continue to keep trying. That's my word that I offer. And Naomi, if you have a word, and if you don't, feel free not to answer, but if you do have a word to leave in this space, feel free to go for it.
Sure. Mine would just be the phrase of, you are not alone. I mean, there's a lot going on with COVID. There's a lot of pressures, there's a lot of worries, there's a lot of change and adjustments that really every human being, maybe it's not identical, but we're all kind of feeling this. So we're in this together, and you're not alone. And I think sometimes that you do feel like the world is stacked up against you, and you're trying to make steps forward, but it feels like you only make steps backward. And maybe some of this information today, maybe for some of you guys, it brought some relief, but maybe for some people, it kind of let you down. But no matter what, no matter what adversity, whatever that we're going through that's difficult, you are not alone. You're not alone in the sense that there's solidarity. There are other people who are in your shoes. Additionally, there are resources, there are organizations, there are people, there are judges, there are departments and what have you, who are interested in helping you and are trying to be available. And they're human beings too. So I think with that commonality, they have a heart. And just like someone like the judge, they're going to listen to both sides of the story. It's not black and white, and it's not going to be like a cold-hearted type of situation. I mean, you have people who are going to listen to what's going on with you. And so just have hope, just have hope that, with that, things can work out. And I really do believe that. Just persevere through it.
Yeah. And I want to thank Shamitria and the Justice Accountability Center for inviting me. It's truly an honor.
Oh no, we lost her. If you guys are listening, I think we had a little technical difficulty with the judge, but I want to hear what she has to say. So we're just going to give her a few seconds.
These are just kind of the realities of what happens. What happens. I mean, these are great tools, and this technology has been phenomenal, but at the same time, but I think this makes it human, because trust me, this happened to me yesterday where it froze on me, and you have to roll with it. And maybe that's something else we can say, is just roll with the punches in life. You know what I mean? We're going to get through this. We're going to get through this. We don't know when, but you gotta have faith, and you gotta lean on, be positive for each other, because we need it. We need it.
So I think we got her coming back. I'm gonna let her go ahead and close it out. think we got you back. You're
You
muted.
can,
Oh, you got to unmute, Judge. All right, there you go.
Okay. All of a sudden, the lights went out and you all went off. Yeah, the lights, it was totally dark. And it came back on, so I signed right back in. But but what I was saying was that I just want to thank you, Shamitria, and the Justice Accountability Center, and Naomi King for inviting me to be part of this wonderful panel, to be able to talk about what is happening in our courts. It is terrifying because you have a court hearing and you do not know what will be the outcome. So it's giving me an opportunity to share with everyone out there as to what to expect and what they need to do in order to come before this court. So I really thank you so much for this opportunity to be able to share my experience, my knowledge of the law in these 9 years that I've been on the bench. So thank you so very much.
You're welcome. All right, guys, you heard it here, and I will continue to bring more panels and more amazing people to connect with our community. But that is all that we have for you today. So Judge and Naomi, Ashe, it was great having you, and I will hopefully work with you again in the future. Bye, guys.
Thank you. Okay,
thank
bye-bye.
you.
Bye-bye.
Thank you so much.
Bye,
Bye.
Naomi. Bye.
Bye.